Thank you for tuning in to the Summer Village Election Training module as part of our 2025 Municipal Affairs Election Training Program. This module will focus on the different election rules for summer villages. However, as many of the general rules for municipal elections apply to all municipalities, please take some time to review our other training videos as they include useful information as well. As a bit of a disclaimer, this video is intended as an introduction and overview of some of the things you need to know as a returning officer. This presentation does not provide a comprehensive review of the legislation and is not legal advice. If you have questions about how the legislation applies to specific facts, make sure to get advice from your legal counsel. General election considerations have been covered in our videos for modules 1 through 4, and modules 5 through 8 will be coming soon. If you need more information on any of these topics, please take some time to watch the videos and review the corresponding returning officer manual modules. The summer village specifics relate mostly to the nomination process and election day. There are also some special rules regarding eligibility and the permanent electors register. Remember that Section 12 of the LEEA begins by stating, "The provisions of this Act that apply to municipalities apply to summer villages, except." I'll explain these differences in more detail. However, while the exceptions are important, don't lose sight of the fact that most of the provisions in the Local Authorities Election Act apply to summer villages in the same way that they apply to other municipalities. Another major difference is found in Section 49. All municipalities are required to prepare a permanent electors register, except for summer villages. Section 49, sub 3.3, provides that a summer village may, but is not required to prepare a permanent electors register and enter into an agreement with the chief electoral officer. As many of you are aware, Municipal Affairs recently clarified that this exception does not apply to summer villages that want to offer special ballots or ensure that elector vouching will be allowed. Let's talk about the summer village nomination process.
This is a list of topics related to the nomination period and their corresponding sections in the LAEA. Please note there have been significant amendments that affect sections 31, 32, and 34. It's a good idea to review each of these sections and the entirety of Part 1 of the LAEA to ensure you understand the nomination process. Please ensure that you are referring to the May 15th, 2025 version of the LAEA when conducting your election. You can also refer to an election checklist specifically developed for summer villages on the Municipal Election Overview page on alberta.ca.
Here's some rules on candidate eligibility in summer villages. A person may be nominated for a summer village council if they are eligible to vote pursuant to sections 47 and 48. Nominees must be at least 18 years old, a Canadian citizen, and living in Alberta in the local jurisdiction on election day. Or the nominee is at least 18, a Canadian citizen, and named on a certificate of title as the person who owns property in the summer village, or is the spouse or adult interdependent partner of a person named on title. Nominees do not have to be a resident of the summer village to be a candidate, but must be entitled to vote in the election and have been a resident of Alberta for the 12 consecutive months preceding election day. You should review the rules governing ineligibility in Section 22 in case you're asked questions. But remember, even if you know a prospective candidate is ineligible, you're still obligated to accept their nomination papers if they meet the requirements of Sections 27 and 28 sub 4. Section 12 states that nominations for a general election shall be received by the returning officer in June or July, or both June and July, on the date and place and between the hours established by resolution of council. In spite of the wording in this section, Municipal Affairs advises that nomination day can only be in June or July, not both. This is something that's been flagged for review. Election day is then 4 weeks after nomination day. Remember that the general rule for the nomination period beginning on January 1st does not apply to summer villages. Instead, Council determines a single date, time, and place for when nominations are to be received. The advertising requirements in Section 26 apply to summer villages. Notice must be published in a newspaper or other publication circulating in the area once a week in each of the 2 weeks prior to nomination day. Or notice must be mailed or delivered to every residence at least 1 week prior to nomination day. In addition, Section 158.1 refers to advertising bylaws passed under Section 606.1 of the Municipal Government Act. If your municipality has passed an advertising bylaw, the method or methods for advertising authorized by that bylaw may be used to provide notice of nomination day. In addition, once these notice requirements have been met, the returning officer may use any other method to post the notice. For example, the municipal website or social media. The notice of nomination is in Form 3SV. Filing of nomination papers. Section 27 sets out the requirements for nominations using Form 4. Nominations must be signed by at least 5 eligible electors and must be sworn or affirmed by the candidate. In addition, Form 5, candidate financial information, must also be filed. Both Forms 4 and 5 should be filed at the same time. Finally, Section 147.22 requires candidates to submit a notice of intent, and Section 147.221 requires municipalities to keep and publish online a register of candidates who have given notice. This is separate from the nomination process. There is no prescribed form for this, so you may collect the required information using your own form. Section 28 sub 4 outlines the only reasons a nomination paper may be rejected by a returning officer. Here are a couple of things to remember. You only need to verify the number of signatures and not whether the people who signed are electors eligible to sign. You don't have the authority to challenge the validity of the information provided. It would be up to an elector or council to challenge the nomination should the candidate be elected. Similarly, if you know that the nominee is ineligible, you do not have authority to reject the nomination. If the nomination paper has not been rejected, the returning officer, or the person delegated by the returning officer, must sign the form to indicate it has been accepted. Section 28 sub 8 requires that candidate nomination information be sent to the relevant ministry's deputy minister. For municipalities, this would be the Deputy Minister of Municipal Affairs, but this is done through the elections database. Contact information for database questions is on the last slide of this presentation. Section 28 sub 10 provides that within 48 hours of the close of nominations, the returning officer shall post or cause to be posted at the local jurisdiction office the names of all candidates that have been nominated and the offices for which they were nominated. Sections 28 sub 6 and Section 34 sub 3 require that the nomination papers be retained for the term of office to which they relate. In addition, a person may request to examine the filed papers during regular business hours and in the presence of the returning officer, secretary, or deputy returning officer. Remember, if you receive more than the required number of nominations for any office to be elected, you must declare that an election is required. Like the notice of nomination day, the returning officer must give notice in the prescribed form, Form 7, by publishing a notice at least once a week in each of the 2 weeks before election day in a newspaper or other publication circulating in the area, or by mailing or delivering the notice to every residence in the local jurisdiction at least 1 week before election day. Advertising can also be done in accordance with your advertising bylaw if you have one. And after meeting the legislative requirements, the returning officer may advertise using any method they deem appropriate. For example, town website, social media. Please note that Form 6 has been repealed, and Form 7 now includes both the notice of nomination information and the requirements for voter identification. Moving on to voting eligibility. Voter eligibility is a bit different for summer villages, and there is often confusion about who is in fact eligible to vote. To be eligible to vote, a person must be at least 18 years of age or older, a Canadian citizen, and reside in Alberta, and the person's place of residence is in the local jurisdiction on election day. Or the person is listed on the certificate of title as an owner of property or the spouse or adult interdependent partner of a property owner. So yes, renters who are resident in a summer village are both entitled to vote and to be nominated for election to council. Section 48 outlines the rules that govern residents. Most important, a person may only be a resident of one place at a time for the purposes of voting. If a person does have more than one residence, that person must designate one residence as the person's permanent place of residence. A person's residence is where the person lives and sleeps, and to which, during an absence, the person intends to return. And a student who attends an educational institution within or outside Alberta, who temporarily rents accommodation while in school, and has family members who are resident in Alberta and with whom the student ordinarily resides when not attending school, is deemed to reside with those family members. Let's look at how electors can prove their eligibility to vote. The rules governing proof of elector eligibility are outlined in Section 53. For summer villages that do not have a permanent electors register, the process for proving eligibility will be similar to what you've done in the past. The elector will complete the Statement of Elector Eligibility on Form 13 SV and provide one piece of government-issued photo ID with their address, or the elector will complete the Statement of Elector Eligibility on Form 13 SV and provide one piece of ID authorized by Elections Alberta that contains both the elector's name and current address. Please note that not all of the forms of ID listed by Elections Alberta will be acceptable for local elections. Only the ones that show both a name and current address may be used. Vouching is still permitted pursuant to Section 53 sub 4 and Section 53 sub 7. However, vouching is only permitted for establishing an elector's address, not their identity. To vouch for someone, the person vouching will need to have proven their eligibility pursuant to Section 53 sub 3 and make a statement in the prescribed form that the elector knows the person being vouched for, knows the person lives at the address indicated on the person's statement, and the person vouching has not been vouched for him or herself. Additionally, the person vouching will need to be on the permanent electors register. So if your summer village does not have a permanent electors register, vouching is not permitted. Municipalities may offer additional voting options for electors depending on the needs of their municipality. These options may include advance votes, special ballots, incapacitated elector at a voting station or at home, and institutional votes. But first, let's talk about some of the things you'll need to have ready for conducting the vote. It's a good idea to have all your supplies ready well in advance of election day. Every voting station must have at least one voting compartment at which electors can mark their ballots in secrecy and without interruption or interference. A compartment must include a table or desk with a privacy screen and a pen or pencil. When setting up your voting stations, make sure no one can see how electors are voting. Election staff should also regularly check that no one leaves any written material or writes anything in the compartment. Section 39 requires ballot boxes to be made from a durable material and constructed in such a way that ballots cannot be removed unless the seal is broken. We can't recommend vendors for election supplies, but we do have a sample supply list up on our resources page. Also, a quick Google search should give you an idea of where supplies can be purchased. or you can speak to your counterparts in other municipalities. Ballots are addressed in sections 41 through 43. The returning officer is responsible for printing a sufficient number of ballots using Form 9. Separate ballots must be used for each office. Ballots must contain a brief explanatory note stating the maximum number of candidates who can be voted for in order not to make the ballot subject to rejection. Each ballot will have the name of each candidate, and the names are to be arranged alphabetically by last name. Municipalities may also have ballots printed in lots pursuant to Section 43 sub 3 if a bylaw allowing this is passed 2 months before the election. Ballots should be ordered as soon as you have a confirmed list of candidate names. Always check the line on the nomination form where candidates have indicated how they want their name to appear on the ballot. This may be different from the name on the first page of their form. Also make sure to select a heavier than normal paper weight or stock so you cannot see through it after a ballot is marked by an elector. Consider using different colors of paper for each of the offices. This will speed up the sorting and counting process. And what about the ballot form for a vote on a question? Section 44 outlines that if there is to be a vote on a bylaw or question, the elected authority must determine the wording of the question on the ballot by resolution. Section 73 requires local jurisdictions with populations greater than 5,000 to hold an advance vote. The section also allows local jurisdictions with populations of less than 5,000 to hold an advance vote by council resolution. When a resolution has been passed, the returning officer has authority to determine the dates and hours that advance votes will be held. No advance vote may be held within 24 hours of election day. What are the requirements to provide notice of an advance vote? The same prescribed format for notice of election day is used, Form 7. The notice is provided following the same rules for notice of nomination day and notice of election. Notice of election and notice of advance vote may be combined on the same notice, provided the publication timing requirements have been met. A fresh ballot box must be used on each day of the advance vote, at the end of which the boxes are sealed and stored in a secure place until they are opened to be counted at the close of the voting stations on election day. Remember, special ballots can only be offered if your summer village has a permanent electors register. Council will still need to pass a resolution before nomination day to offer special ballots, and special ballots may now be offered to any elector who is on the permanent electors register and who applies for one. Electors who are not on the permanent electors register may apply to be added to it pursuant to section 77.1 sub 1.1. Forms 22 through 25 are for special ballots. If you will be offering special ballots, make sure you understand the relevant provisions of the Act, as well as how the forms must be used. At the request of an elector, a deputy returning officer must assist in the marking of a ballot of a voter who is unable to vote in the usual manner. The election worker must read the verbal statement on Form 17 to the elector and then initial it if they answer in the affirmative. A deputy returning officer does not have to complete the statement of friend or relative portion of the form. However, the elector who is unable to vote in the usual manner section of Form 13 SV must be completed. If an elector is accompanied by a friend or relative, the corresponding portion of Form 17 must also be completed. No later than June 30th in the year of a general election, an elector may request a blind voter template and instructions to use the template from the returning officer. If an elector is physically unable to enter the voting station, a deputy may set up a voting compartment for the elector in the voting station or the closest point of access to the voting station that the elector is able to attend. Section 79 deals with elector assistance at home. The section applies to electors who are unable to attend a voting station due to physical disability. If a resolution has been passed, the returning officer must provide for 2 deputy returning officers to attend the home of an elector during the hours of an advance vote or other times fixed by resolution to take the votes of an elector. If the returning officer is satisfied that an elector is unable to attend a voting station or an advance voting station because of physical disability, the returning officer shall include that elector's name and address on a list. Please also be aware that Bill 50 includes amendments to the Local Authorities Election Act to allow for elector assistance terminals. If passed, Section 84.1 will give municipalities authority to pass a bylaw before June 30th, allowing for elector assistance terminals. An elected authority may pass a resolution allowing for the designation of the location of one or more institutional voting stations. The returning officer must fix the times on election day that the votes in the institutions will be taken. Section 80 also allows an institutional vote to be held on the same day as the advance vote is being held. Only those electors who are confined to a treatment center or a supportive living facility that is established as an institutional voting station are eligible to vote at that voting station. Candidates, official agents, and scrutineers may only attend if the vote is conducted at a fixed location in a public area of the institution. They may not attend voting conducted in the room of a resident of the institution. Notice, again using Form 7, must be posted in a conspicuous place in the institution, not fewer than 2 days before the day on which the vote is to be taken. The ballot boxes cannot be opened until the close of the voting stations on election day. The ballots from institutional votes may also be counted at a counting center if one has been designated by the returning officer. Okay, moving on to election day. So under Section 12, election day is 4 weeks after the nomination day set by council resolution. Voting hours are between 10 a.m. and 7 p.m. unless your municipality has a bylaw passed prior to June 30th stating that your voting stations may open earlier. When the voting station opens, the deputy returning officer must ensure that the empty ballot box is shown to the individuals at the voting station and sealed prior to accepting any votes. The seal should ensure that the ballot box cannot be opened without breaking the seal. The box must be placed in the view of the presiding deputy and in the view of all those present in the voting station. If additional ballot boxes are required, each new ballot box should be shown to those present and sealed in the same manner. Promptly at 7 p.m., the presiding deputy must declare the voting station closed. If there are electors in the voting station or in line at the time of closing, those electors may vote. When an elector is in the voting compartment, they must be free to mark their ballot without interruption or interference. Each voting station must have the instructions for voters displayed using Form 10. The instructions should be large enough for voters to read and posted in both the voting station and voting compartments. An elector may only vote once for each person the elector chooses. An elector may not vote for more than the number of persons to be elected to the office. An elector may also only vote once on each bylaw or question. On receiving a ballot, an elector must proceed to the voting compartment and mark their ballot by placing an X on the right-hand side opposite the name of the candidate of the elector's choice. After marking the ballot, the elector folds it to ensure that the initials of the deputy are visible, while the contents of the ballot remain hidden. The elector must then immediately proceed to the ballot box. The deputy must verify their initials without unfolding the ballot and deposit the ballot into the ballot box. The deputy may also allow the elector to deposit their ballot if the elector so chooses. An elector who deposits their ballot into the ballot box is deemed to have voted and must immediately exit the voting station. If an elector made an error on their ballot, they may return it to the deputy who provided it to them. The elector must establish they've made an error, and the deputy must then provide the elector with another ballot in place of the ballot returned. The deputy must write spoiled across the returned ballot and keep it in the appropriate envelope. If an elector states that they are declining to vote, the elector forfeits the right to cast a ballot in the election, and the declined ballot is to be deposited in the ballot box. No one may take the ballot out of the voting station. A person who received a ballot from the deputy and who leaves the voting station without delivering the ballot forfeits their right to vote in the election. The deputy must record on the elector register that the person left the voting station without delivering the ballot to the ballot box. The only people allowed in the voting station for the purposes of the election are the returning officer, deputy returning officers, constables, candidates, official agents, and scrutineers who are authorized to attend, and the electors who are voting. The returning officer or presiding deputy may authorize a person to temporarily observe the voting procedures from a location that is designated in the voting station. The designated location must not be in a position where people can see how electors are voting. Any person who is permitted to observe must leave if the returning officer or presiding deputy asks them to. Candidates may appoint scrutineers or an official agent for the purpose of observing the voting procedures during the advance vote and on election day. A scrutineer must be at least 18 years of age and must present to the presiding deputy a written notice signed by the candidate stating that the person is representing the candidate at the voting station. The scrutineer must make the statement in Form 16 in the presence of the returning officer or presiding deputy. At any time throughout the day, only one of the candidate, scrutineer, or official agent may be present. Any person who has been convicted of an election offense is not eligible to be a scrutineer. Moving on to post-vote procedures. Promptly at 7 p.m. on election day, the returning officer or presiding deputy must declare the voting station closed. Once everybody has left, deputy returning officers can get their envelopes ready and ensure they have all the forms required. Candidates, official agents, or scrutineers are permitted to remain in the voting station to observe the count process. You are not required to provide any tally sheets or forms. A deputy must not permit more than one member of a candidate's team to be present in the voting station at one time. In the presence of at least one additional election officer, ensure that each ballot box is opened and the votes are counted. A deputy returning officer must examine the ballots and reject any ballot that does not have the initials of an election officer, on which more votes are cast than an elector is entitled to vote for, on which anything is written or marked by which an elector can be identified, that has been torn, defaced, or otherwise dealt with by an elector so that the elector can be identified, that is not marked by an X, or on which no vote has been cast by an elector. Rejected ballots must not be counted and must have the word rejected written on the back. If a candidate or a member of their team objects to the rejected ballot, the deputy must write rejection objected to on the back of the ballot. The deputy must also initial the ballot. If a ballot has been incorrectly marked, but clearly indicates which candidate the elector has voted for, the deputy may count the ballot. If a candidate or a member of their team has objected to a ballot, the deputy shall make a note of the objection using Form 18. Every objection must be numbered, and a corresponding number must be placed on the back of the ballot and initialed by the deputy. The deputy returning officer must count the ballots marked for each candidate and prepare the ballot accounting form. At the completion of the count, 2 deputies must sign the ballot account. The account may also be signed by the candidates or the members of their team who observe the count process. As soon as possible, the deputy must provide a copy of the ballot account to the person authorized to sign. Every presiding deputy at the close of the voting station shall certify in words, in the prescribed form, the number of persons who registered to vote at the voting station at which the deputy was designated to preside. At the completion of the count, the ballots and other election materials must be separated into the appropriate packets. Each ballot packet must be sealed and clearly marked on the outside, including the date of the election, the name of the deputy, and the voting subdivision name or number. These packets are sealed inside the ballot box once the count is complete. Supplies must be delivered to the returning officer, and the presiding deputy shall obtain a receipt of delivery. The candidates receiving the highest number of votes are declared elected. If your election results in a tie vote, follow the process in Section 99 for breaking the tie, essentially writing all the candidates' names on identical pieces of paper, which are uniformly folded, and drawing one name from a hat. The returning officer may publish unofficial results as the results are received from the voting station. The returning officer shall, at 12 noon on the fourth day after Election Day, at the office of each local jurisdiction for which an election was held, announce or post a statement of the results, including a declaration that the candidate receiving the highest number of votes for each office to be filled is elected. The returning officer must also report the number of votes for each candidate to the Secretary and to Municipal Affairs through the elections database.
If a recount is necessary, you will need to carefully review sections 98, 98.1, and 98.2 prior to beginning. Please be aware that these provisions were amended as of May 15, 2025. So make sure you review these sections before Election Day and again before conducting a recount. There are two kinds of recounts. The first can be initiated by the returning officer if a candidate, official agent, or scrutineer shows grounds that the returning officer considers reasonable for alleging that the record of the result of the count is inaccurate. The returning officer considers that the number of valid ballots objected to or rejected ballots other than those on which no vote was cast was sufficient to affect the result of the election. Or the returning officer is of the opinion that there may have been an administrative or technical error that may have caused an error in the count of votes. An application for this kind of recount must be made within 44 hours of the close of voting stations. And if a recount under Section 98 proceeds, it must be completed before the time set for the statement of results under Section 97, Sub 2. The second kind of recount shall be conducted by the returning officer if they receive an application from the candidate who is the runner-up or their official agent, when the result is within 0.5% of the ballots received by the candidate with the highest number of votes. Applications for this kind of recount must be made within 72 hours after the statement of results is announced or posted, and if an application is made under Section 98.1, the returning officer must complete the recount no later than 12 noon on the 5th day after the day of the statement of results is posted under Section 97 Sub 2. The timelines and processes for recounts and applications for recounts are strict. If you need to conduct a recount, make sure to review the provisions of the LAEA thoroughly and get legal advice if you need it. For judicial recounts, at any time within 19 days after the close of voting stations, an elector may apply to the court for a recount. The elector must file an affidavit alleging reasonable grounds for believing the ballots were improperly counted and deposit $300 as security for costs and expenses.
All election materials should be stored in a secure location. The secretary, that is the CAO, keeps the ballot boxes with their seals unbroken for a period of at least 6 weeks from Election Day. The contents of the boxes must be destroyed in the presence of 2 witnesses no later than 12 weeks after Election Day, unless otherwise ordered by a judge. The witnesses must make an affidavit confirming they saw the contents of the ballot boxes destroyed. No person may inspect the contents of a ballot box in the custody of the secretary except on order of a judge. And that concludes the presentation. Please remember to review our additional election resources online. If you have questions about school board elections, please contact Alberta Education. Updated versions of the MGA and LEEA can be accessed or ordered through the King's printer, and questions about the elections database can be sent to our information services team.